God save the United States, the state of Tennessee, and this honorable court. Please be seated.
Good morning to everyone. We want to welcome you to the Tennessee Court of Appeals. The panel today consists of Judge Bryson on my right, Judge Davis on my left, and myself, Judge McClarity. Mr. Clerk, is there any preliminary matters we need to consider this morning?
No, Your Honor.
In that case, will you please call the first case?
Barbara Matthews Law v. Halbert Grant Law, Jr.
These are two experienced attorneys, so you very well know the rules. I just need to ask you, Mr. Lawrence, have you reserved any time for rebuttal?
I'm thinking 3 minutes.
3 minutes for rebuttal? In that case, you may proceed. Ms. Cumberland.
May it please the court, I'm Phil Lawrence of the Hamilton County Bar. I represent Grant Law, who is the appellant in this case. First of all, I was reviewing my brief. There's a calculation error on one of the appendices, or appendices, I guess is the word.
Okay.
And I'm going to file a little
Yeah.
errata sheet. It's only on the calculation of Mr. Law's separate property at the very end, just an addition error.
Okay, then.
The court will recall that this came up from the Chancery Court for Hamilton County in, I guess, probably got up here in 21. The trial was ended in 2020, and then on April the 26th of 22, this court issued its opinion on that appeal. And the court did several things. It affirmed the chancellor's finding that a prenuptial agreement was valid. It reversed the finding that a house at 213 West Fleetwood Drive, or Avenue, I guess, on Lookout Mountain was marital property. The court found it to be separate property. The court reversed, this court reversed the trial court's finding that a Fidelity investment account that had approximately $5 million in it was separate property. That was determined to be marital property based on the theory of commingling of other assets. And the case was remanded back to the trial court for the equitable division of the marital estate given the new findings. The court also, this court, in its opinion, also set aside the award of alimony, set aside the award of attorney's fees to the wife's attorney, and instructed the court to reconsider those in the light of the changed circumstances of the case. There were certain assets that remained in place that the court found to be, the trial court found to be apportioned appropriately, and that was affirmed by this court. So it goes back basically for the issues of the equitable division of roughly $5.2 million, and the reconsideration of alimony and attorney's fees. I think it's important to mention a part of the history of the case, in that Mr. Law, the appellant in the case, inherited the Newton Chevrolet dealership from his family, and he operated it until 2007. He was not doing all that well in business and sold the dealerships, but retained some valuable property where Newton Chevrolet had operated in downtown Chattanooga, about 11 acres. And so in 2017, 10 years later, he began the sale of that property that funded this Fidelity investment account that has been determined to have transmuted to marital property. The sale was about 8.6 million, something like that. It netted down to 5 something, and that was the fund that the chancellor was tasked with apportioning between the parties. One thing needs to be mentioned: after the trial was conducted, and really after we argued this case here, one of the assets that Mr. Law was given, called CD Venture Partners 7 LP, increased dramatically in value. It was awarded to him in the divorce case at $717,400. During the time after the divorce, and actually before the court ruled, this court ruled, there was a sale. It increased in value because of COVID had caused the service provided by this company to become extremely valuable, and there was an employee stock ownership plan purchase. And so about $1.3 million went into this Fidelity account. And actually it replaced money that my client had removed from that account, so that it was back to where it should have been for the purpose of the division. So 3 issues are before the court that I've raised: the propriety of the award of alimony, whether or not this bonus of $1 million in alimony in Toledo is justifiable in any sense, whether the attorney's fees are also justifiable, and whether the division of the marital estate was inadequately considered by the court. If you look at the trial court's memorandum in order, he devotes 3 pages to an explanation about this CD Venture Partners 7. 6 pages are on the alimony issue, and there's not one line of explanation, justification, or rationale about how this $5 million or $5.2 million is to be divided. It's never mentioned. Neither is the issue of attorney's fees. It's simply it is order that, I confirm what it was before. So our position on this appeal is that there has been an abuse of discretion by the chancellor in, number 1, making an alimony award to the wife in this case when it's unjustifiable that a person she ended up with $4.8 million. Mr. Law, the appellant, has a somewhat equivalent estate. His separate property, although reduced, is still significant. But Mr. Law is 78 years old. He's been retired since 2007. The court never considered what kind of income $4.8 million would generate, and so there's no justification whatever for an award of $4,000 a month in alimony when these people are in equivalent financial situations. This
marriage is how long?
I'm sorry?
This marriage has been how long?
It was, well, I guess it was 27 years when they finally divorced. This property wasn't sold until after 25 years of marriage. But anyway, the judge's rationale in his opinion for the award of $1 million alimony in Toledo is inconsistent. In one point, he says it's for the wife's support, and on the other hand, he says it's to, make the division of the marital estate equitable. Well, the sequence of decision making is that you first determine what the equitable division of the estate is, and then you award alimony. Well, if it wasn't equitable, he could have adjusted the division of the property before making this award of $1 million. And there's no rationale, no factual basis for there to be, and if I could go over my time, I'll take it off on the end. But
Go ahead.
But there's no rationale for giving her an additional $1 million. I counted 4 lines in the opinion devoted to the issue of awarding $1 million on top of everything else she got. And the point I was going to make was, she didn't testify, I'm going to buy a house. I need to buy a house. I'm not going to rent. And the only house I can get is this one for $1 million. This is pure speculation on the part of the chancellor about needing $1 million on top of the 4.8 that she got from the division of the marital estate. And the same is true about the issue of attorney's fees, that the court said, well, it's going back, things have changed, it looks more favorable for the wife than it was before. Maybe she needs, maybe the chancellor needs to look at this attorney's fee award again. Well, there's nothing in the opinion that justifies the award that was made. So one of the elements of whether abuse of discretion has occurred is whether or not logic or sound reasoning supports the decision. And I think it's absent in this case, especially when the very thing that the court sent the case back to be done, that is the division of this $5 million, is never mentioned. All it says, okay, husband, you get half, wife, you get half. Never a single word about why that was fair. I've got a minute left. And
Okay, thank you. You have your rebuttal. Yes, sir.
Again, good morning. Maybe one issue that wasn't addressed with regard to the reversal of this court is, if you will recall, the court made a determination that the prenuptial agreement was valid, which caused the wife who had been awarded the home place to be removed from the home place and was given to the husband as under the prenuptial agreement. Specifically, with regard to the standard of review, it is obviously abuse of discretion. I will suggest that in the first portion of appellant's brief, he's talking about preponderance of evidence in at least two different times, as opposed to the abuse of discretion. And what is important here, if I'm going to go backwards from what Mr. Lawrence did, because normally what you do is you do make a determination of the equitable distribution of the assets and liabilities of the parties. So let me first correct one statement that was made, which was that the estates of the two people are equal. That's not correct. It is correct that they are very much close to being equal as far as the marital estate goes. But again, in connection with the determination of alimony, specifically, you also take into account separate property. So in addition to the approximately $4.8 million that each of them received, the husband still has separate property of $3,945,988. And the interesting thing about that, in fairness, is this $717,000 investment, there was a 312% return on that particular, and that was marital property at the time of the divorce. Subsequent to the divorce, obviously, it was awarded to Mr. Grant, and indeed, this is his separate property now, and that's what's included in the $3,945,000 separate property. So with that backdrop, let's go to the equitable division. What the judge did with respect to the marital estate, he did his best to divide it 50-50. The only difference between that division is that the court may recall there was $180,000 dissipation of assets by Mr. Law. And so there was an adjustment with respect to that amount that was shifted to her, which gave her $4,863,710 and $4,468,136 for him. And again, as I said previously, the total that he received, if you include his separate property, is $8,414,124 compared to the $4,863,710 that Ms. Law has. And so that equitable distribution, I don't hear a complaint about the equitable distribution with regard to this. It appears to me that it is relatively equal. And what the complaint is now is Mr. Lawrence wants you to adopt his theory of the case as opposed to what the judge's theory in the case is. The judge made a determination that there should be alimony awarded because of the, quote, it's a bad term in my view, but it's a disadvantaged spouse in the sense that, and it's not it's a legal term, it's not a colloquial term that applies in this particular instance. So what we're doing is we're comparing the two estates, if you will, and the two abilities. And to say that, in fact, there's no income that Mr. Law has and that's greater than what Ms. Law has, it's just incorrect. If you look at even the appellant's brief in connection with this matter, he cites the years 2020, 21, and 22. There was no income below $500,000 in any one of those years. And in one of those years, it was $1.3 million. And so he's maintained an office. He still has an office. He keeps an office. He's still doing things with regard to his money. And so, which is obviously, he has been doing this for a long time. And she is a homemaker. And the only real issue that Mr. Lawrence had with regard to the equitable distribution is, well, he should have gotten more because he did more as opposed to this homemaker. Well, I'm sorry. Whether we like it or not, the law is fairly clear on that issue. It's 28 years, but for 28 years, she was a spouse and a homemaker, and she had that role from the day that she got married forward. And that's something that the judge took into. He went through all the factors with regard to the determination, and he went through that factor as well, and he made his decision in connection with this and awarded her, and I've got a number that's incorrect, which is $4,000 a month, is that I wrote inadvertently $4,500 a month, but it's $4,000 a month in alimony. And then he awarded her alimony in solito on the basis that he says that is to provide for, again, it is not necessarily an adjustment to the equitable division of property, which is what, if you look at the appellant's brief, he wants to suggest to you, once you do a division of assets and liabilities, you can't then award them alimony in solito, and that's not the law either. And so, again, with respect to that, he's entitled, and she should, take into consideration what that equitable division is and what disadvantages, if any, that she has. And she does not have any training to make the kind of money that he's been making in connection with this. And so, you know, whether we like it or not, the value of housing is fairly well a judicial notice in connection with this, and the house that they valued at the time that the original divorce was $713,000. And today's world, and maybe, I don't know what, but I'll just say it's going to be more.
So, in Mr. Konvalink, in terms of the number that the trial court came up with for the alimony in Toledo, is it your position that it's based largely on the value of the house that she was initially given, but then became
Well, he said,
his?
the sort of answer to your questions, I can say what the judge said, which is she has to buy a house, she has to pay attorney's fees. So if you recall, the attorney's fees alone in that particular first case was $122,000. And I would suggest that that's probably a very significant piece. To answer your question straightforward, I think that's a very significant piece that was causing him to do what he thought was in his discretion should happen with regard to this particular spouse and the relative needs as between the two of them. Nobody's poor here. I'll be the first to admit that, but that's not what this is about. We've cited you the case law. You all have addressed this before, actually, the Stradienko case. You've had a number of times, but you addressed it in that case. You addressed it in the Murdoch case. You have addressed these issues. All of these issues are not new. These are fairly well briefed, well-written Court of Appeals decisions as to what should be done. And these are where, you know, you've got to get behind the judge and say, okay, is this an illogical result? Is this a really bad result? Is this really an abuse of discretion? Because Mr. Law's lawyer says it's not fair for him to have received an equal amount of assets. He should have gotten more because, you know, he had at a time, even before him, he had somebody else who gave him something, which was Newton Chevrolet, and he undertook and commingled it. But for some reason, you ought to then give him a reward on a new asset that was a marital asset that increased the value of his separate property. But and you know, kudos to him with respect to that. But at the same time, this is not a situation where we're talking about old money anymore. He's actually replaced money that he had spent that he should not have spent. And so that's in the contempt. No, I don't need to get into all that. But again, I would tell you, it is fairly clear that the judge did what he thought. Read his opinion, he deliberated. Mr. Lawrence would tell you he did not. He did. He went through the factors, and he was concerned, and he did it for the purposes of determining what he should do in connection with this. And that's what he decided. And that's why I didn't appeal myself. All right? Thank you. Do you have any questions?
I hear none. Thank you, sir. Yes, sir.
Okay, for my closing minute. You know, in terms of the alimony decision, you know, the leadoff question is, what is the need? Okay, $4.8 million, what is the need? Need and ability to pay. I think they're equivalent. He has some extra separate property, 2 notes that he may or not ever collect, real estate that generates no income. So, and his income in the past has been the sale of assets. He's been cannibalizing what he was inherited and what he made and everything else. He sold off capital assets. Of course, he had $1 million in income in 1 year when he sold off $8-point-something million in real estate. My concern is not that Mr. Konvalink wants to suggest that I'm accusing the chancellor of doing something willful and mean against Mr. Law. I'm saying that he abused his discretion, accidentally maybe, whatever. But the point I'm making is that when you're dividing this $5 million, the origin of which was separate property that funded that account a couple of years before it was divided, doesn't the issue of contribution deserve some passing mention? Not I'm going to make it 50-50. You figure out if I did wrong or right. That is my point. Thank you, Your Honor.
Thank you. I want to thank you both for your presentation. This case and these issues have been submitted to this court for resolution. You should receive our opinion and judgment within a reasonable period of time. If there's nothing further, you may